Good afternoon. I'm James Vann, and this is J.D. Hensarling.
Good afternoon.
We are so thankful that you have dialed in today. We are looking forward to our conversation about lien waivers, releases, and cancellation. So that's a lot, J.D.
It is, but it's an exciting topic.
It is.
And we deal with it a lot.
We get calls a lot about it. So one thing we want to make sure that we encourage you about, right? If you look at those and you go, I have no idea what that's about. It's really easy. You can email them to us. You can call us. We'll be glad to talk to you about them and help answer the questions. I do want to tell you all this. So true story. JD is one of those lawyers that you are so thankful to have in your office because when you get a question you don't really know what the answer is, or you want somebody that has a lot of experience, we run the JD's office. So JD, thank you. It's a pleasure to work with you.
Well, and then I shut my door, look up the answer, and then go back and tell James what I found. So.
That's not true. He knows off the top of his head. He knows. So anyway, y'all, we're going to be talking. Let's look at what we're going to be talking about today. We're going to be looking at what is a lien cancellation, what's a lien waiver, release, and that kind of discharging file claims and lien. Full and conditional types of waivers and then examples, and then JD is going to lead us off into some of the details of that.
Yeah. So the terms, these titles of these documents get used interchangeably. Get phone calls from clients who get documents and send us a lien waiver and say, hey, I received a cancellation, or I received a satisfaction, or hey, draft a release when they really want a waiver. So a lot of people confuse these terms, James.
Yeah.
You've seen that too. We just want to make sure today that we go through each of these types of documents and make sure that y'all understand what we're talking about.
Yeah, that's good. And like I say, even though a document might say it's a certain type of document,
right,
does that always mean that's what it is?
It does not. We've got to go to the text of the document itself.
That's right.
So when we look at lien cancellations, what it sounds like, this is a document that cancels a lien. The lien has been filed with a clerk of court in the county in which the property is located, or the construction project is located. And a lien cancellation is filed in that same clerk of court's office in that same county.
Yeah, and typically, if a lien's already been filed, hopefully, I assume for the most part, an attorney probably did it for you. You'd want your attorney to do the cancellation as well. This makes it easier.
And we attach the actual lien that's file stamped that was filed with the clerk. We'll attach that to the cancellation lien to make sure that only that lien gets canceled.
You don't want any others canceled, that's for sure. All righty.
All right, what is a lien waiver? Lien waiver is a little bit differently. This is a written document that the lien claimant signs. So that's the provider of materials, or the contractor, subcontractor, and it waives their right to claim a lien on the property or the funds being held by the party above them, the owner or the GC. It's generally used to waive rights, and they can be partial lien waiver based on a partial payment on a project at a certain time in the project, can be final payment upon the completion of the project or the delivery of the goods. It can be unconditional or conditional. We'll talk about all of those today.
Yeah. And JD, when you talk about it's a partial payment or final, we know some of the people that are on here will see the list who signs up. And some of y'all have been in situations, as JD says, we're going to talk about the details, where you are locked in because the software won't let you change it, right, on a particular situation. Or you may get these in a PDF version, and you can strike through if it's not correct, right? But it could be a partial payment or final, as JD says, and we'll go into some of those details in just a little bit.
Yep. And then a lien release is similar, but it's a document that releases or cancels a mechanic's lien or a release of liens of rights going forward. Now we're going to talk about whether that's legal or not, but it's actually a release of those rights. So you could have all three of these documents. You could have a waiver, a release, and a cancellation on part of a project or a whole project at the same time.
Yeah. And, JD, meant to mention this when we first got started. If people have questions or if you've got something you want to share, you can send it to by email, a webinar@vanattorneys.com, or either use the control panel on the GoToMeeting on your screen. So you can do either one of those if you have a question.
Yeah, and don't hesitate to ask. I know several of our clients and friends are on this webinar with us, and they've had these issues come up. So please let us know what questions you do have.
So one of the things we want to talk about was the waiver of the subcontractor lien right. So this is from pretty much out of the statute. It says no action of the contractor shall be effective to prejudice the rights of the subcontractor without the subcontractor's written consent upon the occurrence of the following. So these have to work out, right? Sub has given notice to the lien agent. The sub has served the notice of the claim of lien on funds and the real estate to the owner, and the sub has delivered a copy of the notice of the claim of lien on funds to the owner as well, or to the lien agent. So again, this was the statute that they changed when they added the lien agent portion of it. But it's one of those things, and we're going to talk about another part about waiving a subcontractor's lien rights. JD, I know we've talked about it internally here a lot, but I think if you look at the statute, one of the really great things about North Carolina is that our lien rights are in the state constitution. But what has happened is the Constitution says you have lien rights, but then the General Assembly has said yes, but you have to do these things, right? You have to jump through these hurdles. You have to dot this I and cross this T to be able to preserve your lien rights. I'm not sure that's how it was initially decided. I wasn't there. Some people.
That's the way it's done now,
right.
though.
But I think I'd love to see if we could get the right case to get some of that set aside, because people lose lien rights all the time.
They do. And it's really important. We're going to talk about it in a little bit, but that 120 days is really important, that time frame in which lien rights need to be filed or exercised. And then also this subpart of the statute giving notice of the lien agent, you gotta let the lien agent know you're there. So the owner knows you're there. Otherwise, the general can wipe out, all the rights of the subs underneath them.
In fact, the way the statute's written, having to do with the lien agent, if you're not even allowed to file your lien if you haven't given notice.
Right.
The good news is, even though you didn't do it maybe early, you can do it right before you file your lien. But anyway, that's something to look at. So under 44A, and 44A is the general statute that talks about lien law, right, for North Carolina. It says no action of the contractor shall be effective to prejudice the rights of a first-tier sub without written consent of the first-tier sub once it's perfected its claim of lien on real property. That means filing the lawsuit. So outside of what we just read a minute ago, if you have lien rights, file your lien, right? The parties could even above you, right? The GC and a sub that's above you could negotiate a buyout and waive your lien rights before you actually perfect it, which means filing a lawsuit to enforce it, which is wrong, right? But it
happens.
And it's unfortunately the way the law works. I'll never forget, this was maybe, 6-7 years ago. We had a client was owed some money. We filed the lien as quick as we got it in. That's when you had the green cards for certified mail. We got the green cards back.
Before COVID.
That's right, before COVID. Everything's BC or
that's right,
before
COVID.
So we got the green card back that has a signature on it. But the unfortunate part about the green card is there's no date or no timestamp, right? That day, and this was at the end of December, the general contractor wrote some checks to the sub ahead of us, and they waived lien rights and took us out. That wasn't everything that was owed to the sub, but he waived his lien rights going forward, which took us out, our clients' lien rights out. We went through a lot of discovery trying to figure out when they wrote the check and when it was deposited and all that. But back then it was all analog, right? You couldn't have a date stamp. I am convinced they got it, they rushed it, they wrote the checks, and there's nothing we can do about it.
Well, I can tell you another example. I had one recently where A second tier sub came to us, hadn't been paid by the first tier sub, complaining that the general hadn't paid them, complaining that the owner, the same song and dance, right? We filed the lien and then started to hear rumblings of no payments being made, filed a lawsuit probably 2 days later. And then 3 days after that, the first tier sub with whom we had contracted filed bankruptcy.
Yeah.
And we were the only sub that had actually perfected our lien rights because we had filed our lawsuit in time. And so now, even though the first tier subs in bankruptcy, we can get a relief from stay or seek that remedy, get a relief from stay and move forward against a bond or against the GC and the owner for the lien and the unpaid amounts.
Yeah.
So it's important.
Real life stories.
Yep. Important to get that stuff filed on time and quickly.
So once you get a lien filed, JD, how do we discharge? How do we get rid of it?
Well, we're gonna have to discharge it, and so it can be discharged in a number of ways. Number one, the lien claimant's acknowledgement of the satisfaction of lien in writing submitted to the court. That's the cancellation of lien that we talked about earlier. The owner can extinguish a lien claimant's written acknowledgement or can extinguish that by the satisfaction or showing a satisfaction in writing. And then also those lien rights can expire if we don't file the lien within 120 days and then file the lawsuit to perfect the lien within 180 days. And that's of the last date of providing service or work on the project or providing goods, materials to the project. Payment of the lien claim to the clerk. A lot of times they'll put money in the registry of the court or they'll bond it off.
So I know you've had these calls too. Sometimes I get the call or the email that says, "Oh my gosh, they're going to bond this off," and it's like it's a threat. That's not bad news necessarily, right?
The money's there.
So y'all don't. When someone says, "You know what, I'm just going to bond that off," it's okay. They're putting money or either a payment bond in its place that we'll fight over, right? So it's money, which is a good thing, right? So don't let that bother you.
But a lot of times on construction projects, money disappears. This is actually money that's there.
Not a bad thing. That's right. All right. So let's look at waivers just a little bit, because I know y'all get a lot of this, right? The waiver of the lien rights to get a contract. This, probably the people that are on here today don't get this, but it's their customers that might. So maybe it's a first tier sub. The general contractor says, "Hey, look, I want to give you this project, right? You put in a good bid, but you got to waive your lien rights in order to get the job." That is unenforceable in North Carolina, even if it's in writing. Number one, not many of the North Carolina general contractors are going to do that because they know it's against the public policies. Some of the out of state don't really know that. I think even if they sign it, it's ineffective. It's not enforceable, right? So it's against public policy. So you can't require somebody to give lien rights away to get the job.
So if one of our clients or friends are faced with a situation like that, they're handed a contract that includes that language, should they sign over it or what should they do?
That's a good question. I would say try to mark it out, because it's gonna create a problem down the road.
Right.
If you can mark it out early, that'd be great, right? And if they accept it. But if they go, "That's it," or the highway, you probably got to sign it, right? And then argue it later, which is not going to be fun to do, but it happens. So let's look at some other things on lien waivers. Are we combining on this one? I think, right?
Yeah.
So we went through this to make sure we had the right things, right? So on lien waivers, right, signing a false lien waiver constitutes deceit and misconduct subject to disciplinary action by licensing board. Some of y'all might think, "Well, I don't have a problem because I don't have a license before the licensing board." May not be an issue, right?
Well, no, it is an issue because it's a misdemeanor under North Carolina law, and the liability could expand past just the person who signed the false lien waiver. It could also include those who directed him or her to sign it.
So I know there's a company that's on here today, and I think the individual who signed some lien waivers. They were on a project, and a lot of these general contractors are now using software where the sub or the supplier has to go in, and it's basically locked down. It's you submit your pay application, and they get you to sign a lien waiver, but you can't make any changes. In fact, it populates all the numbers, right? And our client could not. They can't. It's not even a PDF, right? They cannot impact that. And of course, our client kept emailing to the general contractor and said, allow me to make this change or change it yourself. You either sign it or you're not getting paid. Right. And this is $100,000 at a pop, right? So it's big numbers. Client signs it, right? And because the project's moving forward, right? They're putting in tons of materials on this job, and lo and behold, at the end, of course, you know what happens. There's a lot of money still owed. And then they try to beat our client over the head in trial of, well, you signed it, that's false, that's a false waiver, right? And I'll tell you, our client did an awesome job. And if you're listening, I'm not going to call your name out, but if you're listening, you did a great job of yes, I did sign it, but it's because they made me sign, they wouldn't change it to be the right thing. So what do you do, right? I mean, I'm looking back in hindsight. I think the thing to do would be, if you can't change it, right? Number one, try not to sign a false lien waiver, right? If you can change it, if it's a PDF, strike it out, right? Initial it, send it back. But if it's a locked down system and they won't change it, send an email to confirm that they won't change it. And you said this is incorrect, right?
As quickly as you can.
Yeah, that's right. At least you've got that backup to then clarify what you were trying to do.
Right.
Any other thoughts on that?
No, just be careful. I think certainly this would apply if there was a general out there signing lien waivers, trying to waive rights of subs underneath them, making false lien waivers like that. It protects against that.
So we talked about this a little bit earlier. This is additional language out of the statute. It says if a contractor or other person receiving payment from an obligor, and that's someone who has an obligation to pay for improvements to the property, if they knowingly furnish to the obligor, purchaser, lender, or title insurance company. Imagine how they got in there. Lobbyists. Anyway,
I can't imagine.
Not that they're bad. It's just everybody's protecting each other. There's a false written statement of the sums due or claimed to be due, then they're guilty of a misdemeanor.
Now that doesn't mean if they made a math error or an accounting error that that they've committed a misdemeanor, does it?
No, I don't. Okay. Well, I don't think so. At least I think that would be explainable, right? And I'll tell you what's interesting. We've had some subcontractors or generals like push this thing like way. I mean, they're just like really dishonest. And it's hard to get a district attorney involved in this statute. You got to be pretty egregious, and at least like the examples I've seen, it's got to be like off the chain bad, right? One or two here or there. In reality, I don't think you can, unless you got a district attorney that's trying to make an example out of somebody, right? It's not going to come to the surface, right? But you still don't want to do it because you don't want that hanging over your head, right? So what document are you being asked to sign, right? We get that all the time. Like lien waivers can be conditional, right? Upon the funds clearing, they can be conditional upon a date certain or a dollar amount that's certain, right? Full or partial lien waivers, or unconditional, and that is just wide open, right? So let's look just a little bit, JD, right? Conditional upon funds, right? Upon the funds clearing. What does that mean?
That means that my waiving of my rights, my lien rights, is conditional upon those funds clearing the bank. If those funds are pulled back, then my lien waiver is no good, and I have not waived my rights.
So this morning we were talking about three of us were hanging out in the hallway actually and talking about releasing rights. Conditional, it could be, hey, look, I'm going to release my lien rights, but I'm not doing it unless the check clears, right? And sometimes if you're afraid that, and I'm not sure how this would work if you're getting close to 180, I'm not going to waive my lien rights if the check bounces, if the debtor files bankruptcy within 90 days. But if you're too close to your 180, that may not work. because
Right.
that's a hard deadline, right?
Yeah. Yeah.
But it can be conditional upon a lot of things, right?
Yep.
And then conditional upon a certain date, right? I'm doing this. I'm going to sign this lien waiver. It's conditional that I'm waiving my rights. If today's the October 5th, I'm waiving my rights up through October 4th or September 30th on whatever it matches to the dollar figure.
Right, right. And we got to be careful that it's not unconditional or some date out in the future. And I think we're
Right.
going to talk about that later, so that we're waiving our rights to work we haven't even done
Right.
yet,
That's right.
or from materials we haven't been paid
Yeah.
for.
I know a couple of y'all have gotten lien waivers that says conditional, right? And you read the language and it seems legit, right? But if you read the next paragraph down, it's giving away everything, right? You got to make sure the whole document matches, right? It's tough.
Read.
All right, so we've got some what ifs here.
All right. Well, what if a first tier sub asks a second tier sub to sign a power of attorney, giving that first tier sub the ability to waive the lien rights of the second tier sub and those below?
Yeah.
What happens in that situation?
So y'all, after we decided we were going to talk about this question came across a construction section that we're members of.
Listserv. Yeah.
Listserv, and I'm like, well, dang, isn't that timely? So a lot of people chimed in on the answer, and we all think that it smacks of the public policy issue that you can't ask someone to give a power of attorney, even though it's not in the contract, right? I'm gonna give you the contract,
Right.
but while I'm doing that, I want you to sign this power of attorney that gives me the lien rights to.
Well, that would
waive
give
you.
them the ability to waive those rights
Right.
at any
It's the
time,
same
whether
thing.
payments are made or not.
Yeah. So if you ever find yourself where a sub asks you to do that, or general is asking you to do that, I think you just say, no, can't, I'm sorry, I can't do that.
I think that's the best policy.
Yeah, you don't want to find yourself in that situation. All right, we got another what if.
All right.
All right, so a supplier receives a lien waiver, and it says dated September 30th of this year, that waives the lien rights through November 30th, 2023, and the supplier is still providing materials on the job. What happens?
Oh boy, don't sign that lien waiver. Okay. All right. This is another example of a lien waiver that you have to read and make sure you match things up, because if you do sign it, potentially, I think that you would waive your lien rights as to those materials you'll provide over the next 2 months.
Right.
So the best policy or practice here is to strike that and change the date, November 30th to September 30th, or don't sign it. And ask them to correct it.
Yeah. And I know we hear this all the time, and it's probably less now than it was 10 years ago. Well, we can't change that. Yeah, you can. It's word processing. Right. It's easy, right? I mean,
well, or like you said earlier, you take your pen, you strike through it, push your initials on it, and then you sign it.
Yeah.
And then make a copy of it so that you have it, so they don't somehow, take your signature off and put it on one that's not struck out. So be careful about that.
Yeah. It's so easy to change these documents now. A lot of times people say, well, I can't change that. That's a company policy. Well, actually you can, because it's just word processing. All right. So let's look at the next what if.
All right. The lien waiver is titled partial conditional lien waiver. All right. We've seen that.
Yeah.
All right. And the body of the lien waiver states, the lien claimant hereby waives all lien rights on the project upon execution of this agreement. What happens?
It looks like they have sold everything. The farm is gone. Right?
Well, wait a minute. But the title says
right.
partial conditional.
That's right. Read it all. Don't just read the top, right? And sometimes even they have it backwards, right? It'll say full, but it's a partial language, right? Make sure you just read everything. And I would say this, not that, I mean, we just happen to have a law degree and some experience with that. If you don't know, or if you have questions, email it, send it to us, right? We'll look at it.
Y'all can probably imagine these questions have come up. Okay.
That's right.
These questions have come up. That's why they're on this slideshow. So just be careful. This stuff happens to people, to companies. Just be careful.
Yeah. I mean, the question we had the other day came from an attorney, right?
Yeah.
Because his client was trying to do that. So just think through those things, right? All right. So we got another what if, right? the subcontractor receives a lien waiver that says the lien claimant subcontractor certifies that all subcontractors and suppliers have been paid for the labor and materials included in the subcontractor's pay application. Well, the fact is that the materials have not been paid for. What happens?
This is running a risk of making a false statement. And so we've got to be careful that if they're going to sign this lien waiver, that everything in there is accurate.
So hold on. The sub is owed money and is owed a lot of money, and it's close. Shouldn't they go ahead and sign it?
No, they shouldn't. Or
Right answer.
Or if they're going to sign it, they should strike through those portions that are not accurate. Again, with a pen, just strike through those initial outside, of the strikings, and then sign it. You just got to be careful. You don't want to make false statements that impact your company or impact others above and below you.
And, I know this happens. We know this happens a lot, right? I mean, there's so much back and forth with these waivers, right? If you're not careful, and it's the ones that you don't really expect to pop up. Those are the ones that you have to explain later. Go, yeah, that wasn't right. But hopefully there's a reason, something you can to explain, but you're better off not having to explain it later.
Well, right. And the question from the lawyer in the deposition is going to be, okay, sir or ma'am, did you sign this document? Had all the materials or subs been paid below you at the time you signed it? No. Okay. Why'd you sign it?
All right. That's not true, is it?
Yeah. Oops.
Which time were you lying?
Yeah.
Oh, I'm sorry. I didn't answer that question.
All three of them? All right. You're required to sign an AIA application for payment that has the following language. The undersigned contractor certifies that to the best of contractor's knowledge, information, and belief, the work covered by this application for payment has been completed in accordance with the contract documents, that all amounts have been paid by the contractor for work which previous certificates of payment were issued and payments received from the owner, and the current payment shown herein is now due. What happens, James?
Well, the example I told before, when it was locked down, you couldn't change it. That's the language from that AIA pay app, right?
Mm-hmm.
So look at it, it says the undersigned contractor certifies, and that's a big word.
It is.
It's a legal word, right? Certifies that to the best of their information and knowledge, right? The information they have and belief that the work covered has already been completed in accordance with, and all amounts paid by the contractor for previous certificates, right? We've had that pop up and they just beat them silly with it. And it could, because the numbers weren't correct, right? And you can't adjust it, right? But I need to get paid because I need to pay for my materials, right?
Make payroll.
Right. And again, they won't change it. So we encourage y'all not to get caught, not to get sucked into it, even though, look, we get it that you need to be paid. We all get that, right? That makes sense. Thankfully, in the case that we had, the judge, I think, believed our client, who did a marvelous job in the testimony. But you got to think through that, right? I mean, if you have somebody and the judge doesn't know which one to believe, that's going to be a hard one to sell on.
Yeah, it is. And I think what we said last time this came up is make your objections known immediately. Send that email, copy as many people as you can, and make it known.
Yeah, that's good advice. All right, so let's look at a few provisions, right? Waiver, this is a language that we have pulled out. So this is a waiver release from conditional waiver and release of lien. It says the undersigned lienor has been contracted by, and you enter your customer's name, a first tier sub, and then enter the GC's name, right, to furnish labor and materials for the premises described and so forth. The undersigned lienor, in consideration of payments in the sum of, put your dollar amount in there, and who's paying the check or who's issuing the funds. When the check has been properly endorsed, for example, if it's a joint check, you got to have both parties, right? When the check's been endorsed and then has been paid by the bank on which it's drawn, it hereby then waives and releases the project, right? The owner, general contractor from any liens and so forth. So that's the condition, that's the condition, right? And it doesn't have to be this way. If you want it to be, it can be, but that's what it's basically saying. The undersigned specifically reserves any and all rights to pursue its claim. In this case, we had I'll explain a little bit more. against the customer's name for the remaining balance due. So we use this language in a case. We were releasing a lien claim, but the overall customer owed more money. We didn't want this to come back to bite us in the rear end, to say, well, look, you got paid in full. You don't need anything else. No, we've specifically said this gives us the right to go after the customer for the balance due and owe it.
Right.
And again, it's one of those things. The more information you put in, the better off you are to help explain it.
Right. Right. Yeah. And so that, you know, it's a conditional, it's also a limited release of lien.
That's right.
Because you're making clear that you're not releasing any rights as to any future payments. This would have been great language for that scenario where the supplier was continuing to supply materials to the job and was signing a lien waiver as of September 30th, but not November 30th.
Right. Yeah, that's a good point. All right, sorry for the smaller print. So this is one that we've used before. It's right. Upon receipt of the undersigned of a check in the form of blank and the sum of payable to you, probably your company. When the check is cleared and endorsed and been paid in full by the bank, then it's released, right? The release covers the final payment to the undersigned for all labor. So in essence, this looks like it's going to probably be, it's conditional, but it's going to be a final waiver.
Yeah, I think it does. I think it releases all of those claims.
Yes. So again, it's worth processing. You wanted to make sure that what it says matches the facts of what's going on the project. Right.
You mean one size doesn't fit all?
No, one size does not fit all. Right. So I don't think we have questions. None have been submitted yet. So we really do hope this is helpful. If you've got questions, I'm gonna make sure we've got our IT guy, Michael Fernall, who helps us, and he just confirmed no questions. So we really hope this is helpful to you, right? If you want help with forms that you use, or if you get forms from your customers or others up the chain, you don't understand it or need some help, let us know.
Most of the folks on this webinar are pretty savvy and have been dealing with these types of issues for quite a while. But I've had several conversations this year with clients or potential clients about their AR policies and procedures. And that 120-day deadline is really, really important. I mean, it's statutory. And if you go file a lien on day 121, your lien rights have expired. Now, you could still probably bring a breach of contract action or an unjust enrichment action, but your lien rights are gone. And so what I've suggested to people, tell me if you do similar, I've suggested that when your AR gets out over 60 days, you need to start thinking about and processing internally about whether you're going to file a lien. Have you filed a waiver? If not, have you made demand for the money? Are they refusing to pay? Is payment coming? Is there some other problem? Maybe it's a chargeback. Maybe work needs to be redone. Whatever. But if the claim is clean and the money is due, at about 60, 70 days, you need to start thinking about filing that lien. What do you think?
100%. I spoke to a group a couple weeks ago where in their industry, in the construction industry, their terms were a lot shorter. But and typically I tell people 60 days, you need to know what's going on. 75, you better have a heartbeat of what's really happening, and don't wait to the last minute.
Right. Yeah.
Yesterday, we were in a mediation that had lien rights in it. Thankfully, we were ahead of everybody else because we filed the liens, filed a lawsuit, and got the mediation scheduled. And we are praying at this point that our client's going to get the money because everybody else is starting to pile up on the parties that were involved in it.
And filing those lien claims can now, this is no guarantee or promise, but it can often lead to a good result for the party making the lien claim. I had one in the past year where a contractor client of ours did some work, got the runaround from the GC and the owner, didn't get paid. We filed a lien claim and then filed a lawsuit. And about 60 days later, that owner went to refinance that project. And guess what? our lien was sitting right there, and
Yeah.
guess who got paid at closing? My client got paid at closing.
That's a good story.
So, hey, it paid to have our
Right.
lien filed on time
Yeah.
and to make the right noise,
Yeah.
you know?
All right, so our next webinar is going to be on November 16th at 3 o'clock. And we're going to be talking about negotiation tips for business professionals. So we hope that will be helpful to you and hope y'all can dial in. JD, always fun to hang out with you.
I enjoyed it. Yeah, thanks. Thanks, y'all.
Have a good weekend.